We have a few minutes left, so what we're going to do is we're going to go to some questions. I'll present the question to one speaker first, and then the other speaker will get a chance to weigh in. So since Aaron came back with some extra slides, Tony, we're going to start the questions with you. So here's the question. Have you found live trial testimony to be a benefit when addressing prior art issues relating to patents and printed publications?
Well, the answer to that question is yes. I believe in, I'm a believer in live testimony. I litigate in both federal district courts and the ITC, and even in the ITC where there's oftentimes you have direct testimony submitted by declaration and there's only live cross-examination. I do believe the best proceeding is live testimony, direct and cross-examination, and I do think that live testimony has the ability, particularly where judges put guidelines on timing for defendants and plaintiffs in terms of the time you're allotted to present your testimony live. I do think there's a benefit, and it crystallizes the issues. Nothing crystallizes the issues better than having live testimony, both direct and on cross-examination.
Thank you for that response, Tony. I'm going to ask Aaron if he'd like to weigh in on that.
Yeah, Sal, I completely agree with everything Tony said. He stated it perfectly. I think, live testimony is almost always advantageous. If you're a skilled litigator and you have a good strategy, you can get a lot out of that live testimony played out in front of a court and played out in front of the finder of fact, which you can't do in an IPR. And, as we talked about earlier, for experts in an IPR, their declaration is effectively their testimony, and their deposition is their cross-examination testimony. And most times that's only being put in front of the administrative judges through paper filings. And so they just don't, there's a lot of underlying factual credibility type determinations that are being made in the district court based on live testimony that just can't be made in an IPR. And so, there's definitely some disadvantages to not having live testimony in an IPR.
All right, we only have a few minutes left. I'd like to ask this question of both of you, so if you could be brief in your response, we'll start with Aaron. Do you recommend filing an expert declaration with the patent owner preliminary response?
Great question. I think the answer is currently, under the rules as they stand today, maybe. My answer would be maybe, which is it depends on it would depend on how nuanced the issues are. So if you have issues of fact that could easily go against you as the patent owner, and you don't want the administrative patent judge's views on those issues to be colored by already taking, at least as a preliminary matter, the petitioner's side on something, you may want to not file an expert declaration with your preliminary response, and then you get the proceeding instituted, and you can put in all of your evidence with your actual patent owner response. Of course, the flip side of that is putting in all the evidence up front gives you the potential of getting the institution kicked and not, the proceeding doesn't happen, and that decision is not appealable. So that's a very strong win there from a strategic perspective. The one additional thing I will say is that if the rules end up changing and the PTAB does formalize the current rules that are being proposed, by which you give equal evidentiary footing to a patent owner's evidence at the pre-institution stage, I think that strongly counsels in favor of putting in an expert declaration at the preliminary stage.
Okay, thanks for that. And Tony, your thoughts on that? Recommend filing an expert declaration with the patent owner preliminary response?
Yeah, and I think Aaron said it perfectly. And again, I would say that, it's really a fact situation, and a lot of these questions that get presented, oftentimes it's hard to answer them without knowing more specifics on the facts of the particular circumstance. But so I would say I totally agree with the way Aaron presented it, and I do agree with the rule change. It would much more certain you'd want to file an expert declaration if the rules change in that regard. But for the time being, I would punt and say it really depends on the facts of each case, and I think Aaron handled that question perfectly.